Hello, my name is Amber Holloway and welcome to the 2022 Secrets Wordle Premises Liability webinar series. Today I'm going to talk about the use of statutory immunity in defending amusement and leisure focused claims such as ski areas, roller skating centers, and horse stables. My presentation today will cover the definitions and scope of the Ski Area Safety Act, the immunity provision in the Act and its application to hazardous identified items therein, and the applicability of immunity to hazards not identified in the statute. Also, we'll talk about the application of immunity to chairlift injuries, the trouble with tubing and tubes, the use of waivers in these types of facilities, and I'll also briefly discuss the use of statutory immunity in defending roller skating centers and horse stables as well. The definition and scope of the Act, and here we're going to be talking about the Ski Area Safety Act. Here in the Ski Area Safety Act, operator means a person who owns, controls, or has operational responsibility for a ski area or ski lift. An operator includes the state or political subdivision of the state as well. Ski area means any area used for skiing and served by one or more ski lifts. And skier is a person wearing skis or utilizing a device that attaches to at least 1 foot or the lower torso for a purpose of sliding on a slope. The device slides on the snow or other surfaces of a slope and is capable of being maneuvered and controlled by the person using the device. A skier includes a person not wearing skis or a skiing device while that person is in a ski area for the purpose of skiing. Some important notes from the definition section. Ski area must contain a ski lift to qualify, at least one ski lift. The definition of a skier includes snowboarders, and anyone riding on a lift or a tow rope is a participant under the Act, not a skier, and ski areas must comply with minimum safety requirements to earn the protection of the Ski Safety Act. Now, a skier does have some responsibilities to be covered by the Act, or responsibilities that are detailed in the Act. So while in a ski area, each skier must do the following. They must maintain a reasonable control of his or her speed and course at all times. They must stay clear of snow grooming vehicles and equipment in the ski area. They have to heed all posted signs and warnings and ski only in ski areas which are marked as open for skiing on the trail sign described in the section C6A-E. So the application of the SASA, or the Ski Area Safety Act immunity provision for hazards expressly identified in the statute. Each person who participates in the sport of skiing accepts the dangers that adhere to that sport insofar as the dangers are obvious and necessary. Those dangers include, but are not limited to, injuries that can result from variations in the terrain, surface or subsurface, snow and ice conditions, bare spots, rocks, trees, and other forms of natural growth or debris which would typically be found in that area, collisions with ski lift towers and their components and other skiers, or with properly marked and plainly visible snowmaking or snow grooming equipment. And as you can see in the slide, I have the Michigan Compiled Law section that you can find these specific provisions in. And here it's MCL 408-342 subsection 2. So what happens when something identified in the statute is not being used for the purpose it is intended and causes injury? The Act essentially codifies the classic common law assumptions of the risk defense. Numerous cases have tested the scope of the risk skiers assume for claims against ski areas and fellow skiers, and generally courts have enforced the Act broadly. Generally speaking, a skier or a snowboarder who hurts himself in a ski area while skiing or snowboarding cannot hold the ski area liable for any hazard identified in the Act or a similar hazard that has been identified in the Act. The clear language of the Ski Area Safety Act establishes that plaintiff's injuries come within the immunity provisions. The statute plainly states that a collision with a ski lift tower and their components comes within the dangers that are necessary and obvious. Further, the SASA explicitly states that the definition of a ski lift includes a tow rope. Plaintiff does not dispute that a metal pole with plaintiff's decedent collided was a part of a tensioning structure associated with a rope tow that was designed to take slack out of the rope tow. In this case, the pole is logically a component of the rope tow in question, which was included in the definition of the ski lift under the SASA. So in this case, because the statutory language is clear, judicial construction was not permitted. And there is a case that shows that there is an exception, and that's Rhoda v. Devereaux, Inc. And that exception would be if something identified in the statute was not being used for its intended purpose due to a lack of signage, as discussed in the recent unpublished Court of Appeals case, and that would be Rhoda v. Devereaux. So with regard to hazards that are not identified in the statute, the court applies the Anderson test, which essentially states that the hazard does not need to be identified. The immunity provision was tested in the case of Anderson v. Pine, Knob Ski Resort, and in that case, the court created two elements. Is the hazard inherent in the sport of skiing, and is the hazard obvious and necessary to the sport? So if the hazard has these two elements, then it is still covered under the SASA. And with regard to chairlift injuries, the SASA grants broad immunity to ski areas involving chairlifts as well. It's important to remember that chairlifts also include tow ropes, and the immunity provision is even in effect if against claims of acts of negligence on the part of the chairlift operator. So that's pretty unique in that it also covers the negligence of the operator of the chairlift and tow rope. All right, here I wanted to talk about the case of Kent v. Alpine Valley Ski Area. Ultimately, in this case, other than generalized opinions that the stop button should be utilized whenever there are children involved, and that any lift carrying children should be equipped with a slow button as well as a stop button, even though plaintiff's expert in this case conceded that the lack of a slow button did not violate the act. Plaintiff's expert pointed to no factual evidence to establish statutory violations by the defendant that could affect or otherwise restrict immunity for operators when a skier collides with a chairlift. So here we have a case where the skier did collide with a chairlift and the SASA immunity still applied. Now, moving on to the trouble with tubes. Again, the SASA grants broad immunity to ski area injuries involving chairlifts and tow ropes, but it currently provides no immunity for snow tubing. Safety devices and industry standards are struggling to catch up with tubes, and signage and waivers are currently the best way to address snow tubing. Now, I wanted to talk about the use of waivers to address liability. So, as most of you probably know, when you go to these ski areas, or when you go there, they have you sign a waiver. So, the Petrick v. 6600 LTD case ultimately stated that there was no merit in plaintiff's argument that the release was invalid for lack of consideration. Defendant's agreement to allow the plaintiff to play softball on its field was adequate consideration because 1, it was a legal detriment, 2, which produced plaintiff's promise to release defendant from liability, and 3, plaintiff's promise to release defendant from liability induced defendant to suffer the detriment. However, waivers signed by parents as to injuries sustained by minors currently appear invalid. More on child waivers. Given the case law and context of legislative enactments and safeguards, Michigan is particularly cautious when it comes to permitting the compromise of any child's rights and strictly adheres to common law preclusion of parental authority in these situations. The court recognizes only very limited and specific statutory exceptions to this general rule. So, generally speaking, a parent cannot waive a child's rights. All right, moving on very briefly, I did want to talk about statutory immunity in areas such as roller skating rinks and horse stables. The Roller Skating Safety Act of 1988, often referred to as RSSA, codifies the statutory defense available in potential claims for injuries arising out of roller skating centers, and it's MCL 445721. That statute provides immunity for roller skating centers for dangers arising out of, but not limited to, injuries that result from collisions with other roller skaters or other spectators, injuries that result from falls, and injuries which involve objects or artificial structures properly within the travel of the roller skater, which are not otherwise attributable to the operator's breach of his or her common law duties. Thus, by participating in the sport of roller skating, a participant assumes the risk of injuries from obvious and necessary dangers inherent to the sport of roller skating. And obviously that should sound pretty similar to the the SASA as well. The Roller Skating Act does not extend to ice skating rinks, golf courses, swim clubs, and tennis clubs. The legislature has also codified a premises owner's immunity from litigation for bowling centers and horse stables under the Michigan Bowling Center Act and the Equine Liability Act as well. And as you can see in the slides, I have the specific statute which covers those liabilities. Again, the SASA is alive and well. The recent decision in Marshall v. Boyne is unpublished, but fairly recent. It's a case that involved a snowboarder in a terrain park, and after snowboarding through the terrain park once successfully, on a later occasion, the plaintiff injured himself. In that case, the court agreed with defendant that the SASA barred plaintiff's claim. Under the SASA, a skier assumes the risk for those dangers specifically that happened here that adhere to the sport of skiing unless those dangers are unnecessary and not obvious. Among the risks assumed are variations in terrain, which we talked about earlier, and the statute imposes a duty on the ski resort to mark certain hazards involving equipment and fixtures, which is not relevant here, as well as a duty to place a sign at the top of a run, slope, or trail. In this case, there was no dispute the defendant complied with the difficulty of that run, slope, or trail, and there was also no dispute that the defendant complied with this requirement. Rather, the plaintiff in this case argued the defendant breached his duty not imposed by the statute to mark the half pipe itself, but the Anderson case makes it clear that when the SASA resolves a matter, common law principles are no longer a consideration. By choosing to ski in the terrain park, which was marked with signage as required by the SASA, and which contained a half pipe that plaintiff saw earlier that day on his first successful run, the plaintiff was held to have accepted the dangers as a matter of law. All right, and I do have some takeaways. Generally speaking, a ski area must make a reasonable effort to maintain a safe ski area. They use the statutory immunity to defend the ski area claims, which is very broad, but they must utilize directed discovery to plaintiff if litigation does occur. Also, you must ensure that a plaintiff can prove that there was no signage, utilize requests for admissions to discover evidence that may support plaintiff's claim. The SASA applies to snowboards and chairlifts, but not tubing. Like I said earlier, the statute has struggled to keep up and is not as updated, so tubing has not really been addressed. But the best way to protect against those types of claims are to get waivers signed by adults and children. Even though waivers signed by children are not valid, it still helps to get those, because there are some limited circumstances when this can be used in the defendant's favor. Again, thank you for attending the use of statutory immunity in defending amusement and leisure-focused claims, such as ski areas, roller skating centers, and horse stables. I did not talk about roller skating centers and horse stables as in depth as I would have liked to due to limited time, but if anyone has any questions on those specific acts, some more in-depth questions, please feel free to give me a call at 248-539-2816, and also my email is listed below. Again, thank you all for attending.